Hello and welcome to G Fun Facts Online, the show that dives deep into the fascinating and sometimes surprising truths hiding in plain sight. When you think of criminal justice, what comes to mind? For most of us, it's the dramatic image from movies and TV. A packed courtroom, a determined lawyer making an impassioned speech, and a jury of 12 deciding someone's fate. It's a powerful symbol of justice. But what if I told you that this iconic scene is a tiny, almost insignificant fraction of how the American legal system actually works? What if I told you that for every one case that goes to trial, more than 19 are settled quietly, behind closed doors? Today, we're pulling back the curtain on the most dominant, yet most misunderstood force in modern justice. We are entering the shadow of the courthouse for a deep dive into the world of the plea bargain. The overwhelming majority of criminal cases in the United States, somewhere between 90 and 95%, are not resolved by a jury's verdict, but through this behind-the-scenes negotiation. At its heart, a plea bargain is a simple trade. A defendant agrees to plead guilty to a crime in exchange for a benefit from the prosecutor. That benefit could be a lesser charge, the dismissal of other charges, or a recommendation for a lighter sentence. It's a system born of pure, pragmatic necessity. With courts drowning in cases and resources stretched to their breaking point, the plea bargain is the engine that keeps the gears of justice from grinding to a halt. But is this engine of efficiency a fair one? Does it deliver justice or just speed? That's the question we're exploring today. The story of plea bargaining is a story of how an informal, almost shameful practice evolved into the very bedrock of the world's most powerful legal system. While the idea of negotiating a case isn't new, our modern, formalized system is a product of the 19th and 20th centuries. In early American history, judges were actually shocked when a defendant tried to plead guilty. They'd often try to convince the person to go to trial, believing it was the only way to ensure justice. But by the 1830s, things were starting to change. In Boston, people charged with minor offenses realized that pleading guilty often led to a smaller fine. The idea caught on and soon spread to more serious felony cases. After the Civil War, the practice really began to accelerate. While some scholars claim plea bargaining was basically unknown before the late 19th century, court records tell a different story. In Alameda County, California, for example, evidence of plea deals dates back to at least 1880. Even then, there was something called implicit plea bargaining, where a defendant would plead guilty, not because of an explicit deal, but with the unspoken understanding that the judge would go easier on them. The early 20th century is when the practice truly exploded. Despite not being fully accepted by higher courts, it became the norm. In New York County, between 1900 and 1907, a staggering 77 to 83% of defendants pleaded guilty. In Cook County, Illinois, in 1926, that number was 96%. For decades, plea bargaining existed in a legal gray area, often seen as unethical. That all changed in the 1960s. In 1967, a major report from the President's Commission on Law Enforcement finally acknowledged its widespread use and recommended that it be formally recognized and regulated. This opened the floodgates for the U.S. Supreme Court to step in. In a series of landmark rulings, the court cemented plea bargaining's legality. First, in Boykin v. Alabama in 1969, the court said a guilty plea must be knowing and voluntary, and the judge has to make sure of it. The next year, in Brady v. the United States, the court made it clear that offering a defendant a better deal to plead guilty is perfectly constitutional. They even went a step further in North Carolina v. Alford, ruling that a defendant can plead guilty to get the benefit of a deal without actually admitting they committed the crime. This is known as an Alford plea. Finally, in 1971's Santabello v. New York, the court declared that a plea deal is a contract. If a prosecutor makes a promise, they have to keep it. These decisions, combined with the ever-growing cost and complexity of trials, transformed plea bargaining from a backroom practice into the undisputed king of the American criminal justice system. But not all plea bargains are the same. It's not a one-size-fits-all solution. Think of it like a menu of options, each tailored to the specifics of the case. The most common type is called charge bargaining. This is pretty straightforward. A defendant is charged with a serious crime, say felony burglary, which could mean a long prison sentence. Through a charge bargain, they might agree to plead guilty to a less serious charge, like misdemeanor criminal trespass. The sentence is shorter, and just as importantly, they might avoid getting a felony on their record, which can have lifelong consequences for jobs, housing, and even voting rights. Next, there's sentence bargaining. Here, the defendant pleads guilty to the original, serious charge, but the prosecutor agrees to recommend a specific, lighter sentence to the judge. For example, in a murder case, a prosecutor might agree to recommend a sentence of life in prison instead of seeking the death penalty. While the judge isn't technically bound by the prosecutor's recommendation, they usually follow it. This gives the defendant a crucial sense of certainty, removing the terrifying roll of the dice that comes with a trial. A third type is count bargaining. This only applies when a defendant is facing multiple charges. Imagine someone is charged with robbery, assault, and illegal possession of a weapon. In a count bargain, they might agree to plead guilty to the robbery charge, and in exchange, the prosecutor drops the assault and weapon charges completely. Finally, there's a less common but still important type, called fact bargaining. This is a more subtle negotiation. Here, the defendant pleads guilty, and the prosecutor agrees to describe the crime to the judge in a way that minimizes its severity. They might agree to leave out certain aggravating facts, like that a weapon was used even if it was, which could trigger a mandatory minimum sentence. By stipulating to a less damaging set of facts, the defendant can receive a lighter sentence. The process of reaching one of these deals is a delicate negotiation, a dance that can start moments after an arrest and continue right up to the minute a jury is about to deliver a verdict. The single biggest factor is the strength of the evidence. If the prosecutor has an airtight case, multiple eyewitnesses, DNA evidence, a confession, they have all the leverage and won't offer much of a discount. But if the case has weaknesses, a key witness is unreliable, the evidence is circumstantial, the defense attorney has more power to negotiate a favorable deal for their client. The key players are the prosecutor, who wants to secure a conviction efficiently, the defense attorney, who is duty-bound to get the best possible outcome for their client, and the defendant, who has to make the life-altering decision to accept the deal or risk it all at trial. Once an agreement is reached, it's put in writing. The defendant then goes to court for what's called a plea colloquy. This is a crucial step. The judge speaks directly to the defendant and asks a series of questions to make sure the plea is being made knowingly, voluntarily, and intelligently. The judge will confirm that the defendant understands they are giving up fundamental constitutional rights, like the right to a jury trial, the right to remain silent, and the right to confront their accusers. The judge has the final say. They can reject a plea deal if they feel it's not in the interest of justice, but most of the time, they accept it, and the deal becomes official. So with this system handling almost every criminal case, is it a good thing? Proponents argue that, despite its flaws, plea bargaining offers huge benefits to everyone involved. For the state, the number one benefit is efficiency. Trials are incredibly expensive and time-consuming. Plea bargains allow the system to process a massive volume of cases without collapsing under its own weight. It also guarantees a conviction. No matter how strong a case seems, a jury is always unpredictable. A plea deal takes that risk off the table. It also helps law enforcement by using deals to get cooperation. Prosecutors can offer a lesser sentence to a lower-level player in a criminal organization in exchange for their testimony against the leaders. For the defendant, the main motivation is obvious: a lighter sentence and a known outcome. Facing a potential 20-year sentence after a trial, an offer of 5 years can seem like an incredibly rational choice. especially if you think you're likely to be convicted anyway. It provides certainty and an end to the stress and anxiety of a pending trial. It also allows a defendant to avoid the stigma of a more serious conviction. And what about the victims? For them, a long, drawn-out trial can be a re-traumatizing experience, forcing them to relive the worst moments of their lives on a witness stand. A plea bargain brings a swift resolution and a sense of closure, without the public ordeal of a trial. In many places, victims even have the right to be consulted during the plea negotiation process. But for every argument in favor of this efficiency, there is a powerful and disturbing counter-argument. The dark side of the deal is where the system's pragmatism collides with our most cherished ideals of justice. The most fundamental criticism is that plea bargaining forces defendants to waive their constitutional rights. The Sixth Amendment guarantees a trial by jury, and the Fifth Amendment protects against self-incrimination. Critics argue that the plea bargaining system effectively renders these rights meaningless for the vast majority of people. This leads to what's known as the trial penalty. This is the massive difference between the sentence offered in a plea deal and the much harsher sentence a defendant faces if they insist on their right to a trial and lose. This huge gap creates a system of coercion. It puts incredible pressure on a defendant to take the deal, regardless of their actual guilt or innocence. And this is the most troubling part. The trial penalty can convince innocent people to plead guilty. Imagine you are innocent, but you're charged with a serious crime. Your public defender tells you the evidence against you is strong, even if it's misleading. The prosecutor offers you a deal. Plead guilty and you get 2 years in prison, with credit for time served, meaning you could go home soon. If you refuse the deal and go to trial, you risk being sentenced to 20 years. What do? It's a terrifying choice. An innocent person, acting rationally, might choose to plead guilty to a crime they did not commit just to escape the risk of a devastating sentence. Studies by organizations like the Innocence Project have found numerous cases of exonerated individuals who originally pleaded guilty. Another major criticism is the lack of transparency. These deals are negotiated in private, away from public scrutiny. We don't see the evidence or hear the arguments. This can lead to huge disparities. Two people who committed the exact same crime might receive wildly different sentences based on who their prosecutor was or how good their lawyer was at negotiating. It also shifts power away from the judge, who is supposed to be a neutral arbiter, and concentrates it in the hands of the prosecutor, who becomes the primary decision-maker on sentencing. While plea bargaining is most famous in the United States, it has started to spread around the globe. Other common law countries, like the United Kingdom, have similar, though often more regulated processes. But in the many countries with civil law systems, common in continental Europe, plea bargaining has traditionally been forbidden, seen as an affront to the principle that a judge must independently discover the truth. However, as caseloads rise everywhere, even these countries are beginning to experiment with forms of negotiated justice, trying to find their own balance between efficiency and principle. Given the serious problems with the system, there is a constant stream of proposals for reform. Some suggest giving judges more power to review and reject unfair deals. Others call for greater transparency, requiring prosecutors to justify their plea offers on the public record. Many believe that strict sentencing guidelines could help reduce the trial penalty and limit the coercive power of prosecutors. There's also growing interest in alternatives, especially for less serious crimes. Diversion programs which offer rehabilitation, community service, or education instead of a criminal record are becoming more common. Restorative justice models, which focus on repairing the harm by bringing victims and offenders together, offer a completely different path to resolution. Plea bargaining is a paradox. It is the pragmatic, indispensable engine that keeps our justice system running. But it's also a system that operates in the shadows, one that challenges our constitutional rights, risks convicting the innocent, and trades the public search for truth for the private negotiation of a deal. As our legal system stands at this crossroads, the challenge remains. How do we build a system that is both efficient and just? Can we reform the deal to make it fairer, or do we need to look for entirely new solutions? One thing is certain. The shadow of the courthouse, where these deals are struck and fates are sealed, will define the landscape of justice for a long time to come. Thanks for joining us on Fun Facts Online.